Hi, I am outside the New Pennsylvania District 9 courthouse where the case of New Pennsylvania versus the Smith family is currently taking place. This case is about 17-year-old Haley Smith who needed an emergency abortion to save her own life, yet she couldn't get it due to the Parental Informed Consent Act, which requires both parents to consent to the abortion. In Smith's case, only one parent could be reached. It was also required that a 24-hour waiting period happen, despite court rulings saying that one parent was okay. When Haley died, her parents sued, saying that this law was unconstitutional and it created an undue burden on her right to get an abortion. In this special episode of 60 Minutes, we're going to get in and explore the history of abortion in the Supreme Court. In the case Griswold versus Connecticut, Estelle Griswold, the executive director of the Planned Parenthood League of Connecticut and the medical director of the same Planned Parenthood, gave information, instruction, and medical advice to married couples on contraceptives. Both of them were arrested and convicted under a Connecticut law that prohibited counseling and medical treatment to married couples for contraceptives. The question that this court raised was, does the Constitution protect married couples' privacies on the ability to be counseled on the use of contraceptives against state restrictions? This applies to our case because, as we know, Haley was not using any form of contraceptives at the time. Another case that comes into play is Webster versus Reproductive Health Services. This is when Missouri put restrictions on abortion. It wouldn't allow government-employed doctors to perform or assist in the procedure, and the state also would not put funding into abortions and wouldn't encourage seeking an abortion except unless it is life-threatening to the woman. This comes into play because, as we know, Haley was in that small percentage of women who needed an abortion to save her life. I got a chance to talk to David Menard, the lawyer representing New Pennsylvania. I'm here with Mr. David Menard, the New Pennsylvania lawyer. How are you, Mr. Menard?
I'm fine, thank you very much. How are you?
I'm good. So, what do you expect the outcome of this case to be?
Well, the way it seems right now, it seems like the court's going to overturn the previous decisions that they made in Planned Parenthood versus Casey, as well as Gonzalez versus Cahart, which is a real shame. Because as those precedents have stated, these waiting periods and consent do not create an undue burden for the mother.
Mm-hmm. So do you think this case will change existing or pave the way for new abortion laws and legislation?
Well, I certainly hope not, because that would be a great shame to our judicial system. But as it seems, it will create great change if these cases are overturned, because that will classify this 24-hour waiting period and the consent of the parents as an undue burden, lessening the restrictions on abortions, late-term abortions for already capable fetuses.
Okay, what makes this case so unique and controversial?
Well, the other side may argue that this woman stands for an unidentified group of women who aren't protected their late-term abortion rights. But she's just an exception. There really is no identifiable group. She obviously had heart complications, but are we really sure that with this late-term abortion that she would have lived?
In the case Planned Parenthood versus Casey, the PA legislature changed its abortion control law in 1988 and 1989. Among new provisions, the law required informed consent and a 24-hour waiting prior to abortion procedures. A minor seeking an abortion required the consent of one parent, while a married woman had to indicate that she notified her husband and her intention to abort the fetus. Many abortion clinics and physicians challenged this new law. A federal appeals court upheld all the provisions except for the husband notification requirement. This is relevant to the New Pennsylvania versus Smith family case in that the 24-hour waiting period is one of the main things that caused Haley Smith's death. In the case Gonzalez versus Carhart, the Partial Birth Abortion Ban Act was challenged again, only this time the Supreme Court deemed that it was unconstitutional because it lacked an exception for the health of women. I also got a chance to talk to Sean Cameron, lawyer for the Smith family. Hi, I am here with Sean Cameron, the lawyer for the Smith family. How are you, Mr. Cameron?
I'm good, thank you. How are you doing?
Good. So, what do you expect the outcome of this case to be?
I expect the Supreme Court to overturn this law and change the previous rulings in Casey versus Planned Parenthood and Aote versus Planned Parenthood.
Do you think that this case will change or pave way to existing abortion laws or legislations?
Hopefully the court will extend the privacy rights of Roe v. Wade to all women, regardless of how unique their circumstances are. The undue burden that was placed on Miss Smith because of this law needs to be overturned, and hopefully we will get that ruling.
Yes. So what is it that makes this case so controversial, different, and unique?
Well, I think the combination of all the previous cases, Casey, Aote, and Hart, make this unique. In each of these previous rulings, the court identified a small minority of women who would suffer an undue burden, but that minority was just such a minuscule amount that it wouldn't be worth pursuing.
Mm-hmm.
But in this, I believe this law created a much more undue burden with the combination of all three of those previous rulings.
Roe v. Wade is the case that paved the way to all abortions that currently happen in the U.S. Roe was a pregnant single woman who brought a class action suit challenging the constitutionality of the Texas abortion laws that prohibited her from having an abortion. In the case of Eilis v. Planned Parenthood of Northern New England, the Supreme Court ruled that it was constitutional for the state of New Hampshire to require both parents to give consent to a minor getting an abortion. They decided that it was only unconstitutional in the case of an emergency life-saving abortion, which was too small of a percentage to consider. As we know, Haley Smith was in that small percentage. I caught up with Mr. Smith, father of Haley Smith, outside the courtroom, and he agreed to give us a brief interview. How are you today, Mr. Smith?
Not very good, sorry to say.
I'm sorry. I'd like to start by saying I'm sorry for your loss.
Thank you, that means a lot to me.
So what are you hoping for when this case gets to the Supreme Court?
I'm hoping that this case will protect girls all over the country, like my little girl, who couldn't get the abortion she needed because I wasn't there, and because of a stupid rule and a stupid law.
Yes, I understand. Do you think that you'll win this case?
I certainly hope so. I would hope that our judicial system would have the power and right to make this right after my daughter died.
So do you feel that that small percentage of females that your daughter was in deserves equal representation?
Everybody needs equal representation, all women, even the small percentage.
I'm here with Katie Finkel, a citizen. Hi, Ms. Finkel. How are you doing today?
I'm good, thank you.
How do you feel about this case?
I think it was really bad and that the girl shouldn't have had to die over this.
I'm here with two citizens. How are you today, gentlemen?
Good. I'm okay.
Okay, so how do you feel about this case?
We don't need any more pro-abortion laws.
And how do you feel?
Abortion is killing unborn children. Okay.
This is Eilis Cunningham reporting for 60 Minutes. We're awaiting the Supreme Court decision before we can further this case.